Yes, loud and clear, Robert.
Okay, thank you.
Nice. You see any of the videos? From the Menkumham, and then you can see Jimmy.
No,
Yeah, I've been in. Hi, Mr. Robert. How are you?
I'm
Thank
fine.
you.
How are you?
Very good, very good. Thank you very much. Thank you very much for your time, and thank you very much for your very kind availability to be participating in our webinar today.
Mr. Robert, you see the videos of any other panelists?
The voice is a bit, how do I say that? Dengung gitu ya, Boy?
It's echoing?
Yeah, echoing, yes.
I think you should lower your volume a little bit, sir.
I'm echoing.
Okay, but Mr. Robert, you can see the videos of other panelists in front of you?
I think so, yes.
All right, good. Thanks.
Is my sound okay?
Your sound is loud and clear.
Okay, thank you.
Sounds clear, Robert. Sounds clear, yeah. Syadan, yang lain Syadan? Panelis yang lain? Syadan?
Iya Bang, lagi di ini.
Syadan?
Ya.
Panelis yang lain gimana?
Lagi di ini Bang.
Oke. Ito Fiona mungkin atau siapa yang ini?
Okay, Mr. Robert, I can ask you to start your video. That's good. Pak Ricardo, you can start your video now.
All right.
I should tell you in advance that you are now also live in Facebook and Instagram. So we are streaming live.
That's great.
Yeah.
Aprila, I'm not sure whether I sent you the new slides yesterday. I just sent them. If you cannot use them, it's not a problem, then we use the other ones. You're on mute.
Kak April, you should unmute yourself first.
Yes.
Have you received the latest slide from Mr. Robert?
Yes, I received the latest slides, and I'm sharing it with Bella right now, because Bella is the one that will operate the slides for Robert.
Perfect. Thank you very much.
No problem. Okay, then we will start in 5 minutes, yeah?
Yes.
Yep.
Any sign of Mr. Andrew?
I think Mr. Andrew will sign in a little bit later.
Okay. Do you know his associate's name?
Cheryl, it's Cheryl.
Cheryl start with C or S?
With C.
Cheryl, okay. Let me find if she's around in the, okay, she's not in yet. Okay. So Cheryl will be one of the panelists as well, yes?
Yes, because she's the one that will sharing the, she's the one that will share the screen. That will be slides for Andrew.
All right.
And
Sharon.
John will also join in a little bit later.
Syadan?
Yes, Bang.
This is already live on Facebook?
Facebook and Instagram, yes, Bang.
It's already?
Not yet.
Okay.
Not yet, right?
Facebook already, Bang.
Yeah, because many journalists ask about live streaming.
The minister is asking for Pak Deddy Kurniadi. Will he be joined the webinar today because his name is on his speech? Bang Jimmy?
Yeah. Would you ask the Sekjen?
Yeah, if he's, I will promote him to panelist.
Yeah. Yeah, please.
Pak Ketua AKPI. Pak Ketua AKPI.
Siapa Dirjen?
Oh, udah ya. Itu
Oh,
Pak Ricardo juga udah ada ya.
ya.
Siapa?
Sorry, itu ada miss call tadi. Saya nggak bisa itu.
Iya itu.
Already join us with us, Mr. Robert, Pak Dirjen.
Oh yes. Welcome. And the minister will be with us in a few minutes. Are we all set?
Pak Dirjen, you remember when we were in Robert's office? And also do it in Netherlands before?
Netherlands, yes, of course.
Yeah.
Of course, I do remember.
Yes.
So you're here in Jakarta or in Netherlands?
I'm in the Netherlands.
I think Robert.
Late evening, right?
It's early morning.
Oh, yeah, morning.
Oh, early morning.
9 o'clock or 10 or 9?
10 o'clock in the morning.
10 o'clock in the morning, okay. Kita udah set, Pak Ketua.
Siap, Pak Dirjen. Siap, Pak Dirjen.
Oke. Okay, we have here with us Pak Dedi Kurniadi, Secretary General of AKPI. Good evening. Good evening. Good day, Pak Dedi.
Good day. Hey. Thank you.
Well, it's already evening in some countries.
Indonesia dan.
It will be evening in Australia.
Netherlands is early morning. Yeah.
Netherlands early morning.
In Makkah Al-Mukarramah is evening. Bang Muhtar, you voluntarily mute yourself or I did not click you on? Okay, so I can ask you to unmute now. Thanks.
So mine is okay, yeah?
Yours
Am
is
I clear?
fine. Yours is fine, loud and clear.
Your voice clear, sir.
The minister is already in place.
We have here with us the Minister of Law and Human Rights.
1 minute to go.
Terima kasih, Pak.
Ya, terima kasih.
Terima kasih, Pak Menteri.
Thank you.
Shall we start now?
Yes, okay. We start then.
Start, yeah. Good afternoon, everyone. Thank you for joining us for today's webinar. My name is Aprilda Fiona, and I am the Master of Ceremony today. Firstly, I would like to welcome our Minister of Law and Human Rights, Professor Yasona Hamonangan Laoli, PhD. It is such an honor to welcome you here to this event. And for the 4 speakers, Mr. Robert van Kellen from the Netherlands, Mr. Andrew Chan from Singapore, Mr. John Martin from Australia, and our Dr. Ricardo Simanjuntak, Chairman of Certifications Board of AKPI, who will be the speaker from Indonesia. Also, let me welcome all participants, our fellow receivers and administrators, academics, and our guests from various backgrounds, among others the Indonesian Court, Indonesian National Police, General Attorney, Ministry of Finance, OJK, National Land Body, bankers, and other government institutions. Today, we are presenting international webinar with the topic of debt restructuring to minimize the risk of bankruptcy due to COVID-19 outbreak. This international webinar held by AKPI, the Indonesian Receiver and Administrator Associations, in which the 4 speakers will share their experiences and best practices of how debt restructuring can result in better settlement than bankruptcy, especially in relation to the impact of the pandemic COVID-19. For your information, we are live streaming this event on YouTube, AKPI channel, Instagram, and Facebook. Okay, before we get started, I would like to read about today's agenda. The first is opening speech from AKPI chairman. The second is keynote speaker by the Ministers of Law and Human Rights. And then we will have presentation sessions from the 4 speakers. And at the end, we will have questions and answer sessions. This webinar will provide e-certificate for participants that stay the entire durations. Without further ado, I welcome our AKPI chairman, Dr. Jimmy Simanjuntak, to give opening remarks. Please, sir.
Thank you, Fiona. Assalamualaikum warahmatullahi wabarakatuh. May peace be upon of you. First of all, I would like to convey my utmost respect to our Minister of Law and Human Rights, Professor Dr. Yasona Hamonangan Lauli SH, Master of Science, PhD. We are honored by your presence and a very insightful keynote speech. I would also like to convey my gratitude and highest appreciation for our respective speakers today, Dr. Ricardo Simanjuntak, LLM, Andrew Chan Chi, John Martin, and Robert Van Galen, for their dedication by sharing their precious knowledge and experience with us in this international webinar today. I am also bid my gratitude to all AKPI members who have worked hard in achieving this event we held today, and for all attendants of this webinar. The topic that we try to discuss today is very important, particularly to those who involved in the field of debt restructuring or bankruptcy. Because at this moment in time, the society of all over the world is simultaneously enduring the same hardship, which is the outbreak of COVID-19 that had brought a hazardous impact, not only to human life, but also to the economy worldwide. The number of debt restructuring act has significantly increased from the beginning of this year and still going up fast as we speak today. Looking at the statistic in Indonesia, legal resource to settle debt by means of court supervised debt restructuring or PKPU has been most opted solution even before the pandemic era. Taking example from the Jakarta Commercial Court, the total PKPU case of the years 2018 is 181 cases, going up to the 285 cases at the end of the year 2019. And as of today, the court has already registered 265 cases. I assume it could reach 350 or more by the end of this year. We may conclude that the pandemic plays a major factor in adding this number. The quarantine and lockdown exercised by almost every country in the world has put business activity on hold for 3 to 4 months, which created a black hole to the profit for almost every business actor. The loss of the said profit resulting in the incapability of repaying their debt, and the creditors suffered damage from the absence of their repayment. The cycle leads to several potential bankruptcy toward big companies and down to small household business. Therefore, PKPU or debt restructuring is the most ideal way out for all of the parties inside the loop. Today, we are about to learn and have insight from our speakers on what is happening in other countries in terms of debt restructuring during this pandemic era, in hope that we can achieve a better understanding and possible adapt a better strategy to the debt restructuring in our country. So without further ado, I officially open this AKPI International Webinar with the title of Debt Restructuring to Minimize the Risk of Bankruptcy Due to COVID-19 Outbreak. Thank you for your attention. Assalamualaikum warahmatullahi wabarakatuh.
Thank you, Mr. Chairman. Such a lovely speech. And moving right along, we welcome our Minister of Law and Human Rights, Professor Yasona Hamonangan Lauli, PhD, as the keynote speaker to address the audience. Please, sir.
Good afternoon, ladies and gentlemen. Distinguished Chairman of Indonesian Receivers and Administrators Association, Mr. Jimmy Simanjuntak, and also Secretary General of Indonesian Receivers and Administrators Association, Mr. Dedi Kurnia, distinguished speaker, Mr. Ricardo Simanjuntak, Mr. Germatin, and Andrew Chan Chi Yin, Mr. Robert Van Galen, and ladies and gentlemen. The COVID-19 pandemic has placed the world in a state of crisis with layer of challenges that leads to significant shift in our socioeconomic and cultural life. In the first 6 months of 2020, COVID-19 has affected 215 million countries with approximately 26 million people infected and taking a death toll figuring more than 600,000. All countries of their economic development are experiencing economic setbacks due to the containment strategy implemented by them, which significantly causing the slowdown of businesses and even close down of businesses in certain areas that ultimately slashes revenues and trigger huge unemployment. The end of this devastating pandemic is unforeseeable. The Organization for Economic and Cooperation Development, OECD, report on supporting businesses in financial distress to avoid insolvency during the COVID-19 crisis. Many countries are urgently deploying measures to support micro, small, and medium enterprises and the self-employed during this severely challenging time. Protecting microeconomy and market is vital, since OECD also predicted that the world economy will face a 6 until 7.6% contraction this year, with unemployment rate climbing to 9.2%. That would represent the deepest recession since the World War, with the largest fraction of economies experiencing declines in per capita output since 1870. Ladies and gentlemen, like any other governments around the world, the government of the Republic of Indonesia places high priority in addressing the COVID-19 pandemic along with its impact on the economy. Developing a policy of striking a balance between effective implementation of the containment strategy to curb the widespread of the COVID-19 and the strategy to ensure that the economy is running is certainly a challenging task for the government. In line with this policy, the government has taken various economic measures, such as the budget for all of these measures that I mentioned is estimated at $9.2 billion. The program is further formulated in the Financial Services Authority Regulation number 11, year 2000. On national economic stimulus as a counter-cyclical policy to the coronavirus disease 2019 outbreak. In this regard, debtors having financial difficulties can apply for credit restructuring to banks or financial companies with lower interest rates, extension of payment period, reduction of principal arrears, reduction of interest arrears, additional credit financing facilities, and 6, credit financing conversion into temporary equity participation. These facilities can be obtained separately or in the form of one package according to the needs of the debtors in the debt restructuring to save the businesses and are prioritized for micro and small medium enterprises. By July 2020, Indonesian banks have restructured a total of 51 billion US dollar, equal to 790 trillion rupiahs in loans according to OJK data. Some 21 billion US dollar worth were micro and small medium enterprises loans from 6.7 million debtors in the remaining 29 billion US dollars were non-MSMEs loans from 1.3 million debtors. This enunciates strong notion that effective debt structuring policy are very much needed. Ladies and gentlemen, debt structuring is perceived to be the right and most effective solution to keep businesses going, and the full support of all stakeholders to policies, regulation, and businesses practice is essential. Indonesian law number 37, year 2004, on insolvency and suspension of debt payment obligation has basically provided almost all the necessary tools for debtors to fulfill their obligation through the suspension of debts by means of debt restructuring. The law also provides the right to debtors to seek suspension of the debt payment obligation filed to the commercial court when faced by insolvency claim by creditors. The law provides a two-step mechanism. One, applying for suspension of debt payment obligation, which both debtors and creditors have the same rights to file the application. Second, submitting reconciliation proposal after the debtor is declared insolvent. According to the Central Jakarta District Court database, within the period of April to August 2020, there were 177 applications for suspension of debt payment obligation. This reflects that there is an increase in the usage of debt restructuring compared to the same period in 2019, whereby there were only 110 applications. The data insinuate that businesses in Indonesia largely prefer to utilize the debt restructuring mechanism. At the time being, the Minister of Law and Human Rights has been working closely with various entities in our concerted effort to strengthen our insolvency law, which expected to curb down the number of bankruptcies, especially for micro and small medium enterprises. I would like to note that recently have found some cases where some receivers deliberately prefer to file bankruptcy instead of find some solution by debt restructuring for their advantage, for their personal advantage. Maybe in some cases, I'm sorry to say, for some personal greeds. I would like to remind all the receivers in this country, this is the time where the country needs to help micro and small medium enterprises, not even micro and small medium enterprises that face these difficulties, including big companies. All businesses are suffering from this crisis. Therefore, I would like to underline my message to all creditors in this country that please have a good faith in helping these business communities. Set aside your personal interest for this time. I would like to know this, and I have entrusted my Director General of General Affairs, Director General Mr. Cahyo, to specially pay attention on this issue and to think about ways to avoid this kind of thing by passing a ministerial regulation for these purposes. Therefore, I would like to call AKPI, Indonesian Receivers and Administrators Association, to discuss these issues with us later on after the seminars. Because the nation, these countries, needs your participation to avoid this, what we call economic killing because of this COVID, as not only Indonesia has made this country suffer from big consequences. And the government has to pay a lot of money for the business community, for the unemployed people because of this pandemic, the consequences of this pandemic to the economics, to the businesses and economy. According to IMF, country report of Indonesia, micro and small medium-sized economy are one of the most important and strategic business sectors that can withstand Indonesian crisis in 1988 and 2008. Up to 2019, micro and small medium enterprises absorb approximately 170 million workers. Moreover, the largest contributor to gross domestic product in Indonesia drives approximately 60% from the micro and small medium enterprise sector down to date. The increase of insolvency cases of MSMEs will simultaneously affect national unemployment rate and worsen the economy since it disrupts the market ability to progress. That is why I strongly urge you all, ladies and gentlemen, especially my fellow Indonesian, my fellow receivers in Indonesia, to especially note this condition that help this business, micro and small medium enterprises, instead of to bankrupt them, please help them, give them a second chance by debt restructuring. I think with the experience of speakers, Mr. John Matten, Andrew Chan Chi-yin, Mr. Robert van Galen from the Netherlands, based on your experience in your countries, we will appreciate your insights in this case, and also we can learn from how you handle this crisis in your country, especially for micro and small medium enterprises in your country. Ladies and gentlemen, the government continues to find ways in support of debtors who still have the potential capability to continue their businesses and settle their debts. The government, I would like to highlight again, the government itself, find ways in support of debtors. So, fellow receivers also has to work hand on hand with the government in handling this terrible condition. So, the government work through possible mechanisms such as workouts, which could be facilitated by the central bank or court to allow informal and speedy settlement. B, constructing separate insolvency law for micro and small medium enterprises. And C, strengthening restructuring mechanism for MSMEs. In the short term, the series of government policies are expected to provide temporarily relief to businesses that are hard hit by the COVID-19 pandemic. Although businesses are protected by these policies, nevertheless, they will have strived to modify or totally change their business models so that they can survive during this COVID-19 pandemic and survive in the post-COVID-19 era. This is so since COVID-19 pandemic have affected consumer habits and commercial practices. An obvious example is the new habit of consumer purchasing online. Through this webinar, best practices of different jurisdictions on various approaches and mechanisms for dispute resolution through debt restructuring schemes will be discussed. I also hope that this webinar will be able to deliver some recommendations for the government to support our current effort to amend the existing insolvency law. Finally, I would like to express my appreciation to Asosiasi Kurator and Pengurus Indonesia, AKPI, for their hard work in organizing this international webinar with focus on topic debt restructuring to minimize the risk of bankruptcy due to COVID-19 pandemic, as well as to all speakers and participants of this webinar. I thank you very much.
Thank you, Mr. Minister. Such an inspiring message.
Thank you.
And
thank you very much. Thank you.
Thank you very much.
And before we start with the presentations, I invite the organizing committee to do the photo session. For Mr. Ministers, the speakers, moderator, Mr. Chairman, please open your camera and smile. And I will count to 3 for the organizing committee to take our picture. 1, 2, 3. Thank you.
Excuse
Terima kasih, Pak Menteri.
me, moderator. Since I have an agenda, I would like to leave, and Mr. Cahyo will be here to replace me. Thank you very much.
Thank you very much.
Thank you.
Thank you very much.
Terima kasih. Thank you, Pak Menteri. Thank you very much.
Terima kasih.
We indeed appreciate very much.
Terima kasih, Pak Menteri.
And now I welcome our moderator for today, Mr. Mukhtar Ali, to start the sessions. Over to you.
Great. Thank you very much, Fiona, and thanks to everybody. Good afternoon, Jakarta, and good morning, Netherlands. Good evening, Australia, and good afternoon for everybody. Thank you very much for your participation in this very seminar. And we just heard what was mentioned by our Minister of Human Rights, that the government pay serious attention on this very important topic on debt restructuring to minimize bankruptcy to the COVID pandemic. And before us, all the participants and all of the speakers have joined us. First of all, that basically the idea of having this seminar is basically to assist the government in managing the situation by issuing the relevant policies and regulation when necessary, and assisting business actors to find the best solution to resolve bad debt-related issues. With the topic of debt restructuring to minimize bankruptcy to the COVID-19 pandemic, there are basically 4 issues to cover in this webinar, and we will see from different jurisdictions. We'll be from Indonesia, and we'll be from Netherlands, Singapore, as well as Australia. Up here before us, the first speaker will be Dr. Ricardo, and followed by Mr. Robert van Galen from Nauta-Dutil, the Netherlands. And then the third speaker will be Mr. Andrew Chan from Allan-Gladhill, Singapore, followed by Mr. Germatin from Northern Australia. There are 4 issues to be covered in this seminar. Will be number 1, is to what extent insolvency and bankruptcy law in each jurisdiction support debt restructuring to settle debt-related disputes. Issue number 2 will be the key features available in insolvency laws and regulation in each jurisdiction that is able to stimulate settlement of debt to restructuring. And number 3 will be whether or not each jurisdiction, Indonesia, Singapore, Australia, as well as the Netherlands, issue special regulation or policies pushing or stimulating creditors and debtors to settle debts through debt restructuring. And number 4 will be as cemented by the Minister of Law and Human Rights, Professor Yasona Lawli. Should there be any suggestion that could be given to strengthen debt restructuring as a better settlement strategy, knowing that the increase of the number of debt-related disputes due to COVID pandemic? So should there be any recommendations given by the speakers, that will be highly appreciated. Right, as a moderator, I will advise that basically each speaker will have 20 minutes to present their material. Then the first will be Dr. Ricardo Simanjuntak. Good afternoon, Dr. Ricardo Simanjuntak.
Good afternoon, moderator.
Yeah,
Thank you.
By way of introduction, Dr. Ricardo is I would say a guru for all receivers and admitters in Indonesia. He graduated from University of Sumatera Utara, USU, took his master in Nottingham, England, and then got his doctoral degree in Universitas Pajajaran, Unpad. He is founder of the Ricardo Simanjuntak and Partners Law Office, a lecturer in Erlangga University as well as in Sumatera Utara University. He was the chairman of AKPI in 2006 up to 2016, and also the expert member in PPHN. So basically, Dr. Ricardo will give a brief overview and outline on the regulatory framework as well as practices on the debt restructuring in Indonesia in the next 20 minutes. The time is yours, Dr. Ricardo, please.
Yeah, thank you. Thank you, moderator. My friend Mukhtar, thank you for a very good starting of our international seminar this afternoon. And I really thank to Minister of Law or our Minister of Law, Professor Yasona Lawli, PhD, that have also addressed is a very, very important and also very, I think, fruitful points in this webinar that I think we can, especially for the speakers, my fellow speakers, Mr. Andrew and also Mr. John Martin and Mr. Robert can also give us insights for the best practices that is now being taken in each of your country to, I think, at least give us more color. I think stronger color for us to bring the point of restructuring to as the really strong means of settling disputes, that dispute between the creditor and debtors in this very, very hard days of cause of pandemics. So I think I'll go to my presentation. If that can be presented, showed, Pak Mukhtar, the presentation, please.
Well, we'll do it with a sec.
All right, so the focus, like I think you have, the topic is debt restructuring to minimize the risks of bankruptcy due to COVID outbreak. That's really the point. Is we are going to give more stressing for the opportunity to settle the debt through the scheme of restructuring process. That's really the point. And why we do that? Because we see it as also the minister have addressed that this pandemic does not only what we call hit the big players, but also hits the middle level, business players up to the micro business players. Yeah, if I can show in my presentation, in very fast, since I have only 20 minutes for my presentation, please. Yeah, I think Professor Yasona has point out in his keynote speech that we are facing actually bad and serious economic problem in this situation, as you see that so many business arrangement, not only the obligation to pay debt to banks, but also business commitment like producing goods and also sending goods, as also the agreement for accomplishing the project. All of that has been really bad, worse affected by this crisis, that creates the problem of non-ability to fulfill or to finish the project as well, or to fulfill the obligation to pay the debts. So this is this cause, I think, the increase of incapability to fulfill obligation to the business partners or investors, or what we call as a breach of contract. That's one of the consequences of the inability or the not able to accomplish the commitment, or also to not be able to pay the what we call it, the debt, and decreasing the capability to pay the debts to the bank. That's what I say, our financing companies. And also the increase of bankruptcy petition as the impact of a failure to do business. So if we see that as a general, then if there is a breach of contract, or assumed breach of contract taken place, then the possibility of the other party that has felt be deprived by the situation, I think they will take three potential legal actions. First, they can bring the party to the court, for taking or suing them as best with the reason of breach of contract, or bringing it to arbitration if the contract is I think agreed to be settled through the arbitration process. Or if the bank, then the bank will just simply execute the collaterals, like fiducia, hak tanggungan, or pledge. Or the other possibility that the creditors will file that to the court for suspension of payment, or for bankruptcy. So if we see that in Indonesia, I think we are quite different with Singapore or Australia, or since in Singapore they have the limit, the minimum amount of the minimum amount for the creditor to bring the case to the court for petition for bankruptcy. For the, I think for the newest regulation that has been reformed August 2019, I think Andrew will explain about it. I think they have now minimum 15,000 Singaporean US dollar as the minimum amount for the creditor to file a bankruptcy cases. But in Indonesia, we don't have such a limitation. So any amount has becomes I think the right for creditors to bring the case to the court, as far as they can assure that or can convince the judge or prove to the judge that the debt has been due and payable, and the debtor at least has another creditor. So if we see in Indonesia, we don't actually apply what we call insolvency test. My next presentation. So we don't apply insolvency test. So there is no obligation for the court to have to prove that the debtor, or to the creditor that have to prove that the debtor has been in insolvent position for the court to decide the debtor bankrupt. Because according that is the difference between our old bankruptcy law and the new bankruptcy law. When we go to our new bankruptcy law, number 37 of 2014, the requirement for the debtor to be declared bankrupt is if the creditor can convince the court that there has been at least one debt that has been due and payable, and the debtor has another creditor. So if these two requirements are fulfilled, it doesn't matter what is the reason why the debtor did not pay the debt. Yeah, if whether the non-payment of the debt is because the debtor is unable to pay or the debtor is unwilling to pay, but yeah, as far as the requirement has been fulfilled, then the court will decide the debtor bankrupt. Yeah. So according to Indonesian law or to Indonesian bankruptcy law, the meaning or the definition of bankrupt is not the same with the insolvent. So if we go to Singapore, I think Andrew or John will explain that later. They have a quite different between the what do you call that, the definition or the requirements of for the creditors to file or to decide the debtor bankrupt, even though in some level we have the same, like commercial bankruptcy. Yeah. So in Singapore as well, as I read some cases in Singapore, that as far as the creditor can prove that the debtor has the claim has been due and payable and the demand to pay has been made within 21 days, then the creditor, the debtor cannot prove that why the debtor did not pay, does not pay the debt, then the petition will be accepted by the court and the debtor will be declared bankrupt. Please. So then when we see, I think also our chairman of AKPI, yeah, Dr. Jimmy has also addressed in his opening speech this morning, as well as our minister. Yeah, we see that the numbers of bankruptcy petition has increased very sharply. So even at this month, it go to almost double. So this shows that our economic is not that good, and we see that the potential petition of bankruptcy or suspension of payment will keep increasing until December, I think, because we see that the economy has not yet made any change. Yeah. So for that, then we come to the question: which is better? Which is better? What do you call that? Result for the creditor? Whether because even though this situation is very hard, but we all believe that the pandemic COVID is not that. The situation that it is still, I think this situation is temporal, not permanent. So I think we are all pray and also hope that this situation will be handled in a very sooner. Yeah. Then if we go to that side and we are successful in doing that, then the economic will go better, and I think the business player will be more able to pay their obligation. So in relation to that, I think we have shown that we see that the potential or the possibility for parties to settle their obligation through the restructuring process. I think in the first alternative that it can be done business to business approach. So by, for example, the debtor can approach each of their creditor. This way is more informal and also can result faster, and also it's not good to the public. But again, business to business approach is not that safe, because the debtor will deal with so many creditors. So even though they can be successful with, for example, majority of the creditor, but as far as the other creditor still reject, then there will be a possibility for the other creditors that does not agree, that do not agree to bring that to the commercial court for petition for bankruptcy as well. So the other one, as the minister have also addressed, that we have POJK 2020, that the government has give specific or special attention to the middle and also small and even the micro business players to be more, I think, to be handled by the bank, not simply what do you call that, terminating the loan agreement, but more give them room to relax or to what do you call that, to restruct it. But I think in this point, I think I have a quite interesting decision from I think one of very new decision from England. Yeah, I think that's the case of Short Gardens LLP versus London Borough Camden Council. That's 2020. It relates to the petition for bankruptcy that was addressed to the business player, where the business player at the time argued that they are not be able to be brought or to be petitioned for bankrupt because the case or the situation or the reason for them not to be able to pay is because of the COVID. But I think in this case, it's very interesting as well that the Court of England considered that, yes, even though England has not yet applied the temporary measure like Singapore has made, they agree that there would be a consideration for the judges to not to allow and not to try to restrict the reason or the way for the creditors to bankrupt the middle and also small creditors. But they put important point in that the small, the middle or small level creditor that must be prevented from that point if the creditors or the small or the middle creditor that has a direct what do you call that, has faced the direct impact of the COVID-19. So this is quite the same. This consideration is quite the same with the POJK because all of the middle and also small creditors that will be handled by the bank through the restructuring process must be the debtor that has a direct impact or direct attack of COVID-19. So it cannot be applied. It cannot be applied, for example, to the creditor that has breach or the contract before the COVID outbreak took place, or they will not be able to pay their debt. That's because they misuse the money or something like that. It must be based on the inability strictly by the impact of the COVID. So this seems to show that the application of the force measure in this case is quite clear. But I think I hope that Robert, Andrew, and or John can help to explain that from their best practice. Continue, but.
Yeah.
Yeah, I think I explained this one. Yeah, I think this is that's why I say that in business-to-business approach, I think that would be in have a pro and also weakness. Yeah, the strength is it's very fast and they can just apply that, or they can just approach the creditors. But in other way, could be the difficulty is sometimes it's not very safe because if there is still a creditor reject the proposal, there would be always a possibility for them to bring that to the court. So please continue. So I think I explained this one. Yeah, I think this is only the explanation of my previous presentation. Yeah, I think the government has, I think, has issues this regulation giving or urge the bank to give more room or to for the debtor, especially coming from the middle, small, and micro business, to not to go to the court for bankrupting or them, but more to give them room for that restructuring. Yeah, with some point that I have put, if you see that in in the color, green color, yeah. Okay, then this is, then I think I would like, because my time is very limited, and continue, Pak? Continue. Yeah, I think I would like to give to give stressing on our Indonesian bankruptcy law. Since we reform our bankruptcy law from what we have in 1999, yeah, to now we have bankruptcy law number 37 2004. So we have basically four facility for the debtor, or 4 rooms, yeah, for the debtor to have like a settlement for their debt through the scheme of debt restructuring. Yeah, first is we call it suspension of payment. Yeah, suspension of payment can be petitioned by the debtor for itself, yeah, or voluntarily PKP we call that. So as far as they can prove that they have at least one creditors that has that has been due, and also they have another creditor, they can file it for themselves. Yeah, and also now under Article 222, paragraph 3, the creditor also can file a debtor for PKP. Yeah, so these tools, yeah, give the possibility not only for the debtor but also for the creditor to not come to the final position of bankrupting, but more to give them room for restructuring. Yeah, so this is I think debtor wants to do that, then they can do that voluntarily, or the creditor also can do that and ask for the debtor business to be restructured. And the other one is when the creditor filed the petition for bankruptcy, the debtor can respond, yeah, or counter that by submitting suspension of payment. So according to our Article 229, paragraph 3, yeah, when the debtor petition for suspension of payment as a counter response to the petition for bankruptcy, our law said that the petition for suspension of payment would be handle first, then the other would be postponed. So this is I think the facilities for the creditors, the debtors, to try to look for a solution for their incapability to pay, to not face the bankruptcy consequences, but more to have room for them to be restructured. Then for if they can build their business better, then they can pay their obligation in a better way. There, please. So if we see that the consequences, as I say, that if that's business to business, if that business to business restructuring point, the party that would be committed to follow the restructuring would be only the party that agree, yeah. But the other that will not agree, they can just simply go to a court to take legal action. But that's different in our debt restructuring through the PKPU. So when the commercial court decided, yeah, that the debtor are in PKPU, yeah, then the consequences is all of the existing claims against the debtor cannot be claimed anymore. It would be put in the state position, and the creditor cannot force the debtor to pay. And this is a kind of collective process to settle the debt, and by asking all of the creditors to register their claims or the account receivables to the appointed administrators, for the administrators to bring that or to pack that into the process or the restructuring proposal that would be posed or that would be submitted by the debtor to all of their creditors. So again, the same when the debtor is declared bankrupt. Because I say you that in Indonesia, when the debtor is declared bankrupt as the consequences of petition for bankruptcy, the bankrupt status is not yet classified as insolvent. So that's why the debtor still has a right to petition or to propose a composition plan, according to Article 144 of Indonesian Indonesian bankruptcy law. So the same, I think the result would be the same with the proposal in the suspension of payment. The bankrupt debtor will propose settlement. Yeah, could be total payment, or but mostly in our practice they will go or they propose the restructuring process. So this will all end to the restructuring process. So what I can want to address in my through my presentation here, that we have actually the means, the what we call statutory means of that gives especially for the debtors to settle their non-ability to pay debts through the restructuring. But the debtor must have the preparation, and also must have a strong intention to I think to have to give a reaction for this. Yeah.
Sorry,
because,
1 minute left, Bang.
Yeah, they cannot just
1 minute.
wait the creditor to petition from them from bankruptcy, then because and the response of that, then the creditor just respond for PKPU. They must prepare. So when they face a severe financial problem, yeah, because of this situation or others, and they are still there, they still believe that they can, if they are given time, they can I think what do you call that, they can bring, or they can put their company to be in a better position. Then for that, they must prepare all of the documents, all of things that can convince their majority of creditors to let them be restructured. Yeah, this is one thing. So I think the advice is to the debtor to not let the situation just by just rejecting the creditor's demand, but not doing anything. On the other side, that the creditor must also consider that insolvency or having the claim through the insolvency process does not really guarantee the maximum amount of the claim. So I think this is something that the creditor and the debtor must consider in a good faith way, so that both parties can have better solution, even though at this time so many debtors are not able to pay their obligation because of the very, very difficult situation. I think I still have one other left, if I'm mistaken, Mokhtar. Can I? Yeah.
Sorry, the time is up already.
Yeah. So this is I think what my position to explain, especially to participants that are engaging in this discussion, as well as to the speakers, that we have the system, but it's through the court, all of them through the court. Something that is not through the court is only what we call business-to-business settlement, and the POJK that the government has also issued. But in other way, we also hear of in Singapore, in Australia, and also in Netherlands, especially when I get the explanation from you, Robert, in your office at a time, that I think Belanda or Netherlands has got quite good progress of this bankruptcy law to give more room for the debt to be settled, not through the bankruptcy process, but through the debt restructuring process. So I think with that, I would like as well to hear best practice and also, issues or insights from 3 speakers to give us, I think, better or stronger understanding to how to strengthen our bankruptcy law to be the law that can facilitate the business players to do their business in a better and in a good way. Thank you very much.
Well, thank you very much, Dr. Ricardo, for the great explanation on the laws and practices in Indonesia. And we understand that basically the laws in Indonesia give weight more on the debt settlement through debt structuring instead of insolvency procedures. But the thing is that there are still, in some cases, even though there is no certainty on the repayment of the receivables by the debtor to the creditor, but still some creditors prefer to use insolvency instead of debt restructuring. So let's move on into the next speaker. There will be Mr. Robert van Galen. Hello, Robert.
Hello,
Well,
I hope you can hear me.
Sure, I can hear you well. Thank you very much. So basically, a bit of, we all listened to what was presented by Dr. Ricardo, as well as by the minister himself, that basically we know that even the minister addressed a very important issue in terms of take a preference on the debt settlement through debt restructuring instead of bankruptcy procedures, and give kind of a warning to receivers and administrators not to take what's called a personal interest and give a priority to the debtor to settle the receivables, their liabilities. Now we want to listen from you, Robert, in Netherlands experience in terms of how the debt restructuring is undertaken, and then on some features that your jurisdiction have in terms of what's called stimulate settlement through debt restructuring, and also whether or not your government gives some issues on, gives some regulations pertaining to debt restructuring. But a bit of introduction, Mr. Robert is a partner, I'm a senior partner in Nauta Dutil, specializing in litigation, restructuring, insolvency, and distress situation, as well as arbitration. Mr. Robert van Galen is specialized in insolvency law with an emphasis on cross-border issues, and he has the firm Insolvency and Restructuring Group. He is a Dutch representative to Untitled Working Group and a fellow of the American College of Bankruptcy, as well as the president of the Amsterdam Lawyers Society. And Robert is consistently listed in Major League tables. Chambers described him as incredibly clever and very academic, as well as very calm under fire. I can see that. The star of the Netherlands in this field. Legal 500 names him one of the leading individuals. Robert became a partner in 1994, having joined the firm in 1985. In 85, he graduated from Amsterdam University. Well, that's about Mr. Robert van Galen, and let's now all of us enjoy the presentation to be delivered by Mr. Robert van Galen. For all of the participants, should there be any question addressed to the speakers, please do so by writing your questions in the Q&A section, mentioning your name and institution, as well as your question to whom it is addressed to. The 20 minutes is yours starting from now, Robert.
Well, thank you very much, Mukhtar. It's a big honor for me to be allowed to participate in this webinar. And I thank AKPI for that also very much. So I will now turn to the proceedings in the Netherlands, the way we do it. Hopefully we can have the slides up, but let me start by saying that in the Netherlands we have 3 types of insolvency proceedings in our Bankruptcy Act. The most important for businesses is bankruptcy. Usually we do both liquidations and reorganizations of businesses in bankruptcy. And then we have proceedings that are called suspension of payments. I will skip those, they are not very effective. And we have a third proceeding, which is debt restructurings for individuals. I will come to that soon. And then on the fourth hyphen, you will see a bill on out-of-court restructurings that's pending in Parliament. It's an important bill, and I will get to that later as well. Now, first, I would like to say something about informal workouts, if I'm allowed to have the next slide. Our Supreme Court made a judgment in 2005 in which it said with respect to informal workouts that the starting point is that a creditor has the right to refuse to consent to an out-of-court restructuring agreement. And that is only different if that creditor is obstructing the out-of-court restructuring agreement, and that obstruction amounts to an abuse of right, and that's a very high threshold. And the reason for that is, in the eyes of the Supreme Court, that an out-of-court restructuring does not provide similar safeguards as insolvency proceedings, where there is an official appointed like an administrator or a trustee. May I go to the next slide? As a reaction to that judgment, with respect to these proceedings for individuals, the debt restructuring for individuals, the government introduced a new, the legislator introduced a new article, Article 287A of the Dutch Bankruptcy Act. And that article provides that if an individual debtor files for debt restructuring for individuals proceedings, he may at the same time ask the court to order a creditor that did not want to consent to an out-of-court restructuring agreement to do so after all. So then there is some kind of an avenue to get that done. Now, the out-of-court, the debt restructurings for individuals, those proceedings are important. They are applied much more than bankruptcy proceedings, and they are applied to consumers or individuals, and also to small businesses which are run by individuals and which are not in the form of a company. There is a law on municipal support for debtors, and that law provides that all municipalities have departments that provide assistance to individuals who run into financial problems. And that assistance is, that support is free of charge. So we have civil servants who are charged with that. And what they do is they assist people who run into financial problems, first of all, with budgeting, if that's bringing a solution. There may be fairly small, but still credit facility to help them. And they help with assistance, they give assistance with the negotiation of an out-of-court restructuring. And if that doesn't yield a result, they give assistance with this Article 287A Dutch bankruptcy request. And you can imagine that if such a civil servant who is specialized in these restructuring helps, it will be easier to reach an out-of-court settlement with all the creditors of a small debtor, and he can put some pressure on them, moral pressure on them to help, and he can also give some kind of independent view that these people are not cheated. So that is a very important instrument we have. And if it doesn't help, then there is the debt restructuring proceedings for individuals, in which a restructuring plan can be adopted and sanctioned by the court. But it's also important that in these proceedings, in the end, if the debtor is an honest debtor, he will get a discharge after 3 years. And you can imagine that the mere fact that he will get this discharge in the end is also helpful in achieving an agreement with the creditors on a restructuring and on a way to go forward. And this is actually our most important way of resolving financial issues of, so to speak, small debtors. And now I will turn to companies. If we look at companies in the form of which are incorporated, the situation in the Netherlands is that usually the banks are the most important creditors. We do not see that much companies that are financed by ordinary creditors, and bonds we only see with large companies. So the banks are the main creditors, and often virtually all their assets have been pledged to the banks or mortgages have been given. And the banks have very strong rights to enforce their security rights, and they also have these rights in bankruptcy. And that means that filing for bankruptcy doesn't keep the banks at bay, at least not for a long time, because in the end they will have the right to enforce their pledges anyway. Other important creditors are the tax authorities, who have preference claims. And if there are ordinary creditors like suppliers, often there are credit insurers who play a role. But in general, the role of the ordinary creditors is subordinate. And as I said, financing with bonds, you don't see much with medium-sized companies. So just have a brief look at bankruptcy. What solutions do we have once there is a bankruptcy? Well, first of all, there are the rules about a composition in bankruptcy, a rescue plan on which the creditors have to vote. But unfortunately, in our bankruptcy proceedings, a composition is only possible with creditors that do not have preferential rights and are not secured creditors. And for that reason, the composition so far is not effective. It can only be applied in a minority of cases. The other possibility is to have an asset transaction. What often happens is that a new company is established and that the assets are sold to the new company. And sometimes or often it is refinanced by the same banks, and the proceeds of that sale will then be distributed. But as the ordinary creditors are usually out of the money, this will be applied to the banks as well. But it will at least give some relief of the debts, because the new company will be financed in a healthier way. And it's an important way and also a quick way to restructure a company. But it always involves a trustee, because in bankruptcy, always a trustee is appointed, and the trustee will have to judge whether the sale is a sale at a fair price. So that is what we have in bankruptcy. Now, as I mentioned, the banks have a strong position, and what you often see is that the banks, prior to opening any insolvency proceedings, they may collect the secured assets, they may collect the receivables, or they may enforce against these assets. And also they may enforce against shares in subsidiaries of the debtors if those are pledged as well. If they do sell off in a private sale, so not in an auction, they will need the consent of either the court or of the debtor, if the debtor is willing to cooperate. And if the court has to give its consent, there has to be a market exploration or evaluation. And then there's always the issue if there is an alternative bid. So if the banks want to enforce and want to basically sell the subsidiaries off to a new company, someone may come and have an alternative bid. So this is a bit of the background, and it shows that the banks have a strong position, and that's the way you have to look at out-of-court restructurings. What you often see is that there are negotiations between banks if multiple banks have financed the debtors, or sometimes other secured creditors are involved, and they basically come to an agreement on the refinancing, and the ordinary creditors will then not receive anything because they are out of the money anyway. But this kind of action is difficult to do if numerous ordinary creditors are involved, and then often the solution will have to be to let the company go in bankruptcy. These kind of out-of-court restructurings, which often happen, have advantages because if the alternative is to open bankruptcy proceedings, that means that the creditors, the secured creditors, and the debtor lose control over the process because a bankruptcy trustee is appointed, and he may think that a reorganization plan that has been prepared prior to those bankruptcy proceedings is not the best solution, and he will look for another solution. So that means there is a loss of deal certainty. And if the alternative of pledge enforcement against the shares of the subsidiaries or the assets is considered, then, as I mentioned, that requires court consent if the debtor doesn't give it or cannot give it. And that also means some kind of loss of control. So it is attractive to the secured creditors. Again, they are the most important creditors usually, to achieve some kind of out-of-court restructuring and get to an agreement amongst themselves. Now, this is a solution that works if the main creditors are secured creditors, and it does not work if there are numerous ordinary creditors, or if there's a mixture of creditors, and therefore it is important that we will have a new law on out-of-court restructurings. And one specific feature of that instrument will be that the restructuring takes place out of court, but in the end it will be confirmed by the court. And that is what we call the VOA. It is presently a bill, but it's a bill in a very far stage, because it has passed the second chamber of parliament. That is, strangely enough, the first chamber you have to go to with new legislation. That second chamber of parliament has a right of amendment. There have been a few amendments, but that process is done. The bill is now pending in the first chamber of parliament, which also has to vote on it, but which has no right of amendment. And it is expected that it will adopt this bill very soon. So we know, because no more amendments are possible, what that law will amount to, and we expect to have it within a few months. And by the way, it's actually an implementation of a European directive, but the Netherlands are one of the first to really implement that directive, which is from the summer of 2019. So what are the main features of this VOA? Well, the debtor offers a restructuring plan to some or all creditors and possibly to its shareholders. And as I mentioned, the court needs only to be involved after the voting has taken place in order to decide on the confirmation. I should mention that the court may be involved at an earlier stage, for example, in order to order interim measures or to resolve disputes that there may be about this plan. The plan is similar to a Chapter 11 reorganization plan in the United States. I will not discuss all the similarities and differences, but I just mention a few features. First of all, the plan may involve secured and preferential creditors. You may remember that earlier I said that the present compositions in bankruptcy can only involve ordinary creditors, but this new plan may also involve secured creditors and preferential creditors. So that's an important step forward. All the affected creditors, all the creditors that will lose some rights or have the rights changed, will be put into classes, and each class has to vote on the plan. And there is a 2/3 threshold in amount for each class for adopting the plan. And if one of the classes or more classes reject the plan, then there is a possibility for the court to cram down on such a plan if it thinks that on the whole the plan should be adopted. And this structure is, well, it's similar to what happens in Chapter 11 in the US, and also in Germany there is a similar system.
Sorry, 3 minutes left, Robert.
Excuse me?
There are 2 minutes left.
I have 2 minutes left. I will, that will be sufficient.
Thank you. Great.
The contents of this plan are free, and I should also mention that it's possible when you adopt such a plan to terminate contracts that are burdensome for the debtor, but the rights of the employees cannot be changed under the plan. And finally, clauses which say that contracts terminate automatically, or that the other party to a contract can terminate them when these proceedings are opened, those clauses are not effective. Now, turning to COVID-19. There will also be a new law which is in a consultancy stage right now on delayed payments. That law will provide for the possibility to suspend a request for bankruptcy. The court can suspend it for 6 months, actually 3 times 2 months, if the financial difficulties are caused by COVID-19. So it's more difficult to obtain bankruptcy of a debtor. And the court can also order a suspension of any enforcement measures for a similar period. And other measures taken by the government are that the government can take over the obligation to pay wages. They will then have to be, some of it may have to be repaid later, but they basically assume it. The government can provide credit facilities. That is a very complicated, enormous patchwork of rules. And the tax authorities may also give an extension of payment. And then there is a lot of case law right now about payments of rentals. You can imagine that shops and restaurants, for example, find it very difficult to pay their rents. And then there are disputes with the landlords, and there's a lot of case law. In some cases, those rents do not have to be paid. Now I'll get to my last slide about support for debt restructuring. I should say that in general, there has always been a strong support for restructurings, allowing businesses to continue. I mentioned out-of-court restructurings with the banks, and we also have these asset transactions in bankruptcy, which usually can be done pretty swiftly. So in cases where the debtor is primarily financed by financial institutions or bondholders, out-of-court restructurings are often very effective. And then with bondholders, I mean organized bondholders who have meetings that can vote on plans. And in cases where there are not organized ordinary creditors, but where there are ordinary creditors, the WOA will provide a solution, because then we can have a plan in which minorities can be forced to accept a haircut, for example. In cases of individuals, there are supporting agencies by the municipalities that can promote a settlement. And last, COVID-19 has brought a number of instruments which inter alia allow payments to be suspended. Well, thank you very much for giving me the opportunity to tell something about the way things are done presently in the Netherlands.
Thank you very much, Robert. Very insightful indeed, basically, yes. And we understand from Robert that basically there are some features offered by the government during this COVID, one of which is like, you know, the new law will be issued, WOHA will be issued and will be effective very soon. And then, you know, some specific measures, temporary law or delayed payments is newly implemented, where it's not easy to file for bankruptcy of the debtors due to the COVID-19. And also some facilities given by the government, particularly on tax, as well as on some incentives to the companies for payment of wages, that sort of thing. Now let's move on into the third speaker. It will be Andrew Chan. Mr. Andrew Chan. Hello, Andrew. Hi. Can you hear me? Well, thank you very much for joining us. So we have all enjoyed the presentations of Dr. Ricardo as well as Mr. Robert van Galen. Now we want to see, I want to learn from you on Singapore experience. We know that Singapore has recently issued IRDA IRDA, insolvency, restructuring and dissolution. We also know that basically Singapore has declared themselves as a Pacific state restructuring hub, and also some features introduced by your government to support debtors in terms of, you know, not easy to file them for bankruptcy. So those are, I think, something that I'm a bit aware of the situation in Singapore. Before we start with your presentation, let me share with everybody on your background. Mr. Eddie Chan is the partner in Alan Clarity Law Firm based in Singapore. His many years of practices covers international arbitration, litigation, and restructuring and insolvency. He was admitted in Singapore in 1983 and pursued his LLB in Singapore University, National Singapore University. And Andrew has been consistently noted as a leading restructuring and insolvency lawyer in the Legal 500 Asia Pacific, Chambers Global, and Chambers Asia Pacific, Bruce Legal, as well as FLR 1000. In Chambers of the Pacific, he has been described as a prominent figure in the market and is praised for the technical skills, knowledge, and contribution to the profession. He is extremely good, successful, and persuasive in negotiation. Andrew has been inducted to the Legal 500 Hall of Fame for restructuring and insolvency. That sounds wonderful, Andrew. Now, well, that's a bit of introduction. Now I think it's time for us to learn together from Andrew on Singapore experience. I'm sorry to tell you that basically we are a bit of behind schedule. 20 minutes by the schedule. If you can make it further, it would be great. So we have more time for Q&A later on. Time is just 20 minutes. Move forward. Thank you.
Okay, terima kasih, Muta. I will keep to my time. Assalamualaikum to everybody. So the position is this. I've got 20 minutes and I'll keep to the 20 minutes. I'm not interested here to tell you what are the contents of Singapore insolvency law. I'm here to share with you the concepts. Seperti mana Menteri had said, the Menteri had said earlier. He said, really people are suffering. These are difficult times. He asked the receivers to think about, the other businesses and what. Yang tu saya faham. That I understand. I understand because what you face in Indonesia, some of those issues we also face. But what we do in Singapore, you cannot immediately take into Indonesia. Indonesia is at a different stage of development. Before I go to my slide, is think about, because I want to share these different experiences, because this will help guide, not just tell you what is Singapore law, but to share our different experiences. That's what this topic is about, and see how we are different. In the past, after 1998, in the Asian financial crisis, if you look at Indonesia's law, it's a very well-drafted law, but it was drafted to be a bit more pro-creditor because the IMF was interested in putting funds in. So you do a restructuring, your suspension of payment, 270 days you fail, you ternyata pilot. That means you go into bankruptcy or insolvency. But that kind of thinking, what was in Indonesia in 1998, the times have changed. So in other words, is the law, and that's a question for Indonesia, which came about in 1998, still suitable today? What can a Singapore experience share in terms of some of these topics? Let me tell you the story. Next slide. Now, Singapore has got a well-regarded debt restructuring center. Interestingly, most countries try to say, we want to be an international financial center, we want to be an international export center, we want to be this and everything. Singapore is maybe one of very few countries in the world to want to be an international debt restructuring center. We want people to come to restructure in Singapore, as some people will go to maybe New York or even London or maybe Netherlands, yeah, and what have you. Why? Because having a good restructuring center, we help not only help elder people, we also help, I think, develop professionals. And the point is this, we're not doing this to take work away from others, but there are certain features, because we are a financial center, for example, where we can work together, play on each other's strengths. There may be a domestic restructuring in Indonesia and one international restructuring. Because why? You want to bind all the banks. Where are the banks? A lot of them are in Singapore. Kita boleh kerja sama. We can work together. And that is what we are trying to do. What are these things which a debt restructuring center must be? Because is it possible to be a debt restructuring center and yet to be an international financial center? In restructuring, I want moratoriums, I want stays, I want to slow down enforcement, I want to give you time. For financial, if I'm a bank or what, I want to write good rights to enforcement. Berchangga, they seem to contradict each other. Is there a way to strike a balance so that everybody's interest can be looked at? And this is what I want to examine today, because this is what you must be really asking yourselves a hard question, not what is there, but why it is there. And that's my focus. The first thing, of course, if you're trying to look at the various needs, you must have various procedures, because some procedures are better than others. The first is, of course, liquidation. You must have liquidation because some companies must be allowed to die, must be allowed to come to an end. It cannot be all safe. Because if you all safe, I mean, these zombie companies, I mean, they're incurring more debt. It's even worse. Some must be allowed to die. We need to think about how to do that. All right. So it cannot be that there's no failure. There must be space for failure. There must be space for what we call debtor in possession, a system whereby management, honest management is allowed to continue again. And you must have that. A system which doesn't have debtor in possession, the insolvency practitioners are not always the best person to run the company. The receivers, sorry, no disrespect, or liquidators are not always the best. Sometimes the debtor management must be allowed to continue, but with safeguards. So you got a scheme of arrangement in Singapore. And the scheme of arrangement's got safeguards in terms of transparency, court control, and so that when you lead a process where the majority number, 3/4 in value of the creditors or classes of creditors approve and the court approves, it binds everybody. And if you can't meet the class, the court has some powers of cram down. But it's with very strong safeguards. Then you got judicial management. Sometimes dishonest management, terrible persons cause the trouble. You continue to put them in debtor possession, doesn't work. So you need a judicial management, someone independent to come in. But in all these insolvencies, you have a situation whereby, like I say, it's an inroad into rights of creditors. So there must be safe harbors. Misalnya, for example, for the moratoriums, imagine if everything I stay, nobody's going to do business. So for example, for derivatives, for securitization, where you want to raise debt, debt securities, bonds or what have you. So there are certain safeguards or carve-outs for some of these particular aspects. Why? Because this enables at this difficult time, because people are not less willing to lend when you know they're going to have problems in solvency. So there must be appropriate safeguards. We got a safeguard or carve-out for securitization. We got safeguards for certain commercial ships. We got certain safeguards in respect of various aspects. But this is an idea. Cannot be only insolvency, cannot only be creditor rights. In other words, what I'm telling your Singapore's experience is precision tooling. It's like engineering. The engineers spend so much time, or the people, the scientists, to do precision. That insolvency system must be precise enough. And we have done a lot of it. The question which was raised in the Q&A by Vina Ratwani, how do I do a restructuring? If at the end of the day I do a restructuring, I need the collateral, but yet the creditor wants to enforce it. I mean, how to do business, how to drive a car? Very good question. So for example, in our bankruptcy law for individuals, you make the person bankrupt, but you cannot take away the tools of trade for the individual to earn his livelihood. Later, I'll tell you for the new COVID Act, we got carve-outs as well. But the law needs to then, the point is, it's not just think about insolvency law, think of where the balance, where the carve-outs. It means a lot of work. But in Singapore, we have achieved it and we're going to continue to achieve. But any restructuring, you just say, oh, you can do this because the law is this and what have you, fine. But you also need tools how to do it. When World War II happened, Winston Churchill said, he told America, lend me the tools and I'll finish the job. Let me tell you what are some of these tools. Next slide. Because I need my tools, my perkakas, right? So one of the main things which we came about, look, you have looked at this. So one of the things is Singapore is always very forward thinking. We have prepared ourselves and we brought about a major act. Muta, you raised very well IRDA, the Insolvency Restructuring Dissolution Act. Some people say, wow, Singapore very good, I can come in major act. It's so short a time. Actually, forward planning. We have thought about it. This law was passed in 2018, but we went in a lot of precision. There are about 50 subsidiary legislation. I mean, it's not the main act, but we are ready. So when the time came, Singapore is ready. This brings into being personal insolvency, corporate insolvency, because if you have in our past, our laws was everywhere. We bring them together. What are some of these tools? Because I said, like Winston Churchill, give me the tools, I'll finish the job. For example, rescue financing. Imagine a case where you have a creditor, secured creditor, whose debt is 100 million. The value of the asset now is 200 million. You say, no, I want to continue because I want to earn interest. I refuse to enforce. You keep it there. Then what happened? Because these are security rights. I cannot interfere security rights. This is a viable company, but I cannot do anything. So rescue financing allows a rescue financier to come in, to be equal, even in some cases exceed the secured creditor, provided, of course, there are enough safeguards that the secured creditors are adequately protected. It means basically they're no worse off. But why is it not the case where I have a $200 million property, somebody is prepared, and only $100 million in debt? Why cannot it be that somebody is prepared to finance 50 million, be allowed to finance? Because now I can't finance. Why? Oh, because got priority, because got negative pledge covenant, this thing, that thing, no this. I mean, all the problems, look. There may be at times with strong safeguards to allow rescue financing, fresh monies. So we have that tool in Singapore as part of our law. You borrow some of these ideas from the United States. One thing about Singapore is this, we got no problems borrowing the best ideas from everybody. We got no ownership or you are right or I'm right. We only have an interest in what is good and what is best. Litigation funding, one of the big issues which actually arises is, how to have funding and what have you, and I can sell claims which are normal claims, but can I sell clawback claims? That means those which belong to the creditors. One of the things in the past under common law is you shouldn't be selling claims. You shouldn't be selling things which are personal because these are matters for the liquidator. So Singapore law now says, yeah, you cannot sell because the liquidator, the judicial management must control. But I allow you to sell the proceeds. So a professional still controls the litigation, but you can sell the proceeds. By selling the proceeds, I can raise funds for recovery. So we also have that under IRDA. I've talked about schemes, arrangements, and cram down on certain thresholds. Actually, that's been around since 2017. The point is this, it cannot be strong just creditor rights. We need to achieve the balance, a balance which at the end of the day may actually be good for creditors. Imagine if you are an unsecured creditor, the main secured creditor holds out, you may be worse out. Of course, now you're a secured creditor, I don't want to interfere. But sometimes the banks are under a secure position. Really with the right safeguards, that's the point we need to strike. A system with good, reliable courts, good, reliable system, good, reliable transparency. But you can only do this if you learn to strike the balance, if the laws are there. Precision tooling. Next slide. So the other thing is this, and this came about in IRDA. One of the worst things, so people say freedom of contract. So your contract says, and it's very often common in many contractual clauses, if you start judicial management of schemes, those are our restructuring provisions, I terminate the contract. Freedom of contract what? So what this means is a company who tries to restructure, starts a scheme arrangement, starts judicial management, sorry, too bad, I'm terminating you because the contract says so. But there's no breach. I don't care, my contract says can terminate. So what actually happens is if I'm out of the money, because in this particular contract, or actually this is money losing contract for me. You start, I terminate. Oh, you are wrong, I'm not going to pay you. Imagine the loss of value, how to restructure. You restructure, you die because that's your contractual clause, freedom of contract. So Singapore said, look, we need to restrict this. Of course, we need some safeguards, like derivatives, like certain bonds. Imagine I do bonds, I cannot terminate. Right, so we're subject to some safeguards and carve-outs. I've mentioned like derivatives contracts. But generally, if it's a supply contract, in certain kinds of construction, but I mean, those kind of things, don't say you're billing for me, actually you're losing money, but now I want to do a restructuring. I tell you what, now the person supposed to bill walk out. Cannot. So what this tool does, and the new IRDA is this, it suspends your right to terminate by reason of insolvency or schemes arrangements or judicial management once you have started the JM or judicial management of schemes. We need to do things like that. It cannot only be freedom of contract. Some people say terrible, interfering. No, I think we need this, especially for a time like this. Soft tools. Your insolvency or process you must regulate insolvency practitioners. We have upgraded our regulation. We struck the balance, we give them some autonomy and what have you. But also there must be penalties. We have now made, under IRDA, directors a bit more accountable. Last time it needs to be a fraud or whatever. Now, if you basically carry on business without any reasonable prospects of payment, unless you've got good excuse, it can be liability. So we strike a balance. We give you a bit more. We interfere a bit more on the rights of creditors. But at the same time, we raise the standard for directors. That is what a restructuring system needs to do. Strike that balance. Next slide. Now, we also are increasing on mediation. So I've been involved in mediations because sometimes, look, fight, argue. Untuk apa? For what? Well-skilled mediators, and we are promoting this, have a place in trying to achieve, and Singapore has now this mediation convention. It's going to be enforceable elsewhere in other countries as well. And more and more countries come aboard the mediation conference. We need to do that. There's so many more aspects of IRDA which I have no time to talk about. But let me move on to the next. So the first big point which I talked about is IRDA, and I also talked about mediation. The second big thing which we did, I hear very interestingly what Robert is trying to do for temporary measures in his country. We have already done it. In April, we passed a law. So what has happened is that Singapore rushed through the parliament. I think in a matter of weeks, we drafted a full law. 3 big aspects of the law which I want to tell you about. So the first point is it suspends certain categories of contracts. It doesn't suspend all contracts, because this is important, because, you know, imagine you interfere all contracts. So to the earlier question which Rina asked, for example, it interferes with the enforcement of security where it is over equipment used to generate business. So the point is, we're not interfering in everything, but it's precision tuning. Imagine you go and enforce against the very tools, the very machinery. So our law is very calibrated. It looks at what kind of contracts to terminate. Tourism contracts, of course, you know, wow, I agree to, what do you call it, book your whole hotel or sort of this or so. I mean, so what they've done is for, I think 7 categories of contracts or whatever, they look into, okay, this category we need to intervene, it's COVID related, but there are safeguards. You need to show it's related to COVID. In the meantime, we cannot take certain actions. And at the end of the day, you have an assessor, a very cheap process. I'm an assessor. We decide our matters in a matter of, it's hard work for us, but my decisions are rendered within 2 weeks. Very quick. And then after that, some adjustments, some kind of between, maybe at most the whole process. Of course, prior to this, that's when it comes to me, there is a prior process to that. But you're looking at a question of maybe a few months, actually a few weeks, maybe just into a month or two. This is decided. You have it or you don't have this. The other big category is this. The second big bullet point in this COVID Act is the higher thresholds for people to start bankruptcy or winding up. So in the past, I can issue a stat demand. Ricardo mentioned that 21 days. So for insolvency now, it's 6 months. But there are caveats. The ERDA says, if you show that they're trying to dissipate assets or whatever, you don't have to wait for the 6 months or you file. Okay, so does it mean, you see, what you need to do, you need to stall, you need to make more time for them to issue the stat demand, but you must have safeguards. Our act and our laws, ERDA together with this act, has the right balance. Remember, precision tooling, balancing, and that's important. The other thing which we do under this act, which it's not my slides because I think I wanted to keep my time, is this. We have relief against tenancies. So what they do is government funds 2 months. And if you are a Singapore entity or a non-profit organization, basically if it's for the companies, SMEs, there's some thresholds for SMEs, more than 50% locally owned. The landlord, not only government give 2 months, landlord must also give 2 months. You see, you cannot just rely on negotiation up to the parties, receivers, thing or whatever. You cannot just rely on itikat by good faith. It doesn't happen. We need to be able on strong safeguards to intervene in this difficult time. I talked about a bit earlier about the laws have been lessened for wrongful trading, easier to make out cases against the directors. But in this difficult time, we have suspended some of those provisions. We need to allow people to take a bit more risks. Okay, but if you're fraudulent, we're going to get you anyway. But this is a time where it cannot be freedom of contract. This is a time where we need to have or facilitate what is essentially to do the right thing. Next slide.
1 minute left, Andrew.
Okay, 1 minute left. 2 big points.
Yeah. Right.
Not only must we look at Singapore itself, we must look at cross-border, because a lot of insolvencies are cross-border. You don't help each other, you don't recognize and give effect to each other's laws, it's not going to work. We need to cooperate. We must create some antara different, and we must work before the difference of this. Because everybody thinks only on themselves is going to have a problem. Then Singapore says, I'm not going to do the finance, I'm not going to allow this to respect. Indonesia is not going to allow maybe the assets. No, it's not working. We need to find a system subject to appropriate safeguards, how they can be cross-border recognition in insolvency, in insolvency. And we have adopted the model law. Last point is this, akan datang. All those things which I said in terms of ERDA is good, but it's a one-size-fits-all. Problem is, all of these procedures can be costly, can be expensive. So what is going to come akan datang is you're going to have a simplified scheme of arrangement process. You're going to cut through some of the process. You're going to have a simplified liquidation. You're going to get some professionals who are going to do this at very low cost. It's sort of like a national service. Some of the lawyers are going to do it pro bono, but certain limited procedures akan datang. So what you have is this ERDA with the tools, the features I talked about. You have the COVID law, which already is in effect, is temporary because it's only maximum 1 year, but you need something temporary. And you have akan datang coming soon. a simplified procedure. This is what Singapore has done. That's all I have to say.
Thank you very much, Robert. Just in time. Very, very interesting and fruitful information you share with us. So, but I know that you basically have a lot of things to share with us, but time is still limited. Maybe next time we may arrange another arrangement, particularly to discuss about IRDA or some other features that Singapore government has promoted to take restructuring action.
Yeah,
Now,
Lisa, I'm happy to.
Yeah, sure, great, thank you. I know you have a lot of what's it called, like information to share or ideas to discuss with, but maybe next time. Basically, what we understand, what we learned from Andrew is that basically, in terms of features, there are some features introduced by the government on a temporary basis. For example, like suspension of enforcement of certain categories of contract will be and also higher threshold needed for individual companies to be declared insolvent. Those are some of the features that provided by the government to assist business actors in resolving their payment obligations. Now let's move, because we have not much time left. Let's move into Mr. Germatin from Northern Road for Sydney. Hello, Germatin. Hello, Mr. Germatin.
Hi there. Yes.
All right. Great. Thank you very much for joining us. Basically, as like other speakers, we want also to learn from you in terms of how things happen in Australia and your experience in dealing with this very situation, particularly in dealing with restructuring as well as on insolvency in Australia. That like we want to learn from you on this particular matter. Before we start with Mr. Martin's presentation, let me share with you a bit of background of Mr. Germatin. He's a partner in Northern Road for Australia, and one of Australia's leading insolvency and restructuring law experts, based in Sydney, with a particular specialty in cross-border insolvency. In 2016, John was appointed to the board of prestigious International Insolvency Institute, and he currently also serves as a vice president. And in July 2017, John presented a paper to the UN 50th anniversary Untitled Congress in Vienna about conflict and consistency in cross-border insolvency judgment. Together with Mr. Stuart Atkins, John is drafting new insolvency laws for the Republic of Myanmar and has twice presented to members of the Parliament's upper house. He was admitted in 1987 by High Court of Australia, and in 1985 admitted by Supreme Court of New Wales. I think that's a bit about the background of Germatin. As Germatin, I think now, starting now, you have 20 minutes to share with us about your ideas and experience. Thank you.
Well, thank you very much for that introduction, and thank you for the previous speakers as well. Can I particularly thank the Minister for his very insightful presentation. He has pointed out the importance of finding an appropriate response to the pandemic and the economic impacts of it, and the implications for insolvency laws across Australia. At the end of his presentation, he called for solutions for the problems that all jurisdictions will be facing. I intend in this presentation to concentrate on solutions and also to provide what I think is important, which is an international perspective. Every country is going to be different, but there is a menu of items that need to be examined very closely in order to observe international best practice in dealing with the bankruptcy impacts of this pandemic. Aprilda, if you can put my presentation on, thank you. And as I go through the international perspective, what I will do at the same time is to illustrate the international best practice concepts by reference to what is happening in Australia, and in that way provide the Australian perspective. If we can go to the next slide, please. I think it's important to provide context here. We are dealing with insolvency laws, and at its heart, an insolvency law is a compact between three participants, three stakeholders. Debtor and creditor are two obvious ones, but the third one is society. And I think that's a really important stakeholder when we deal with COVID-19. As I listened to the Minister speak and heard that there were 170 million workers in the MSME market in Indonesia, and that 60% of GDP is contributed by MSMEs, we can see the societal impact of not providing an appropriate response to the COVID pandemic. It's just so important to get right. The other insolvency concept that is integral to finding solutions to the problems that are besetting the world at the moment is to focus on a key insolvency concept, a key bankruptcy concept, and that is enterprise value. Anything that a law can do to maximize the value of a business that is facing financial difficulties will benefit everyone. It will benefit creditors because they will receive a higher dividend. It will benefit employees because more of them will keep their jobs. So that's a central focus. Now let me turn to the international perspective, and I refer here to the incredible work of the International Monetary Fund in addressing the bankruptcy aspects of this pandemic. They have prepared a framework that any country ignores at their peril. In that framework, they have identified three phases to the response to this pandemic. And I've got the three phases there up on the slide. The first is the immediate measures for an interim period to deal with the emergency that beset us all back in March, April, May, and June. The second phase is what they call the transition phase, and that is building up to the third phase, which is how does a country deal with the debt overhang? How does it deal with the insolvency and financial distress aspects that need to be resolved in order for their respective economies to be brought back to a sense of normality? So let me work my way through the first phase first. And yes, the next slide after that one, please. So the purpose of this first phase, which was to deal with the immediate crisis earlier this year, was threefold. You can imagine the social disruption if businesses are shut across the country and people are out of employment and no longer earning wages. So part of the interim measures had to be there to prevent social disruption. Part of the way of doing this was to provide breathing space for debtors. And the third objective, a very important one, is the courts won't be much use if they're absolutely overwhelmed with cases and can't appropriately deal with them. Next page, please. So the IMF recommended a number of emergency measures, and we've heard a number of them from the previous speakers, and there's a sense of commonality here. They're pretty much common sense, but they're important. Obviously, you couldn't have everyone enforcing their debts at the same time, or the courts would have been overwhelmed. So there had to be moratoria put in place. Eviction for rental defaults was a recommendation. So important. You can't run a business out of premises if you're locked out of the premises. Utility contracts, water, electricity, gas, shouldn't be permitted to be terminated because of the short-term financial cash flow difficulties. For individuals, it's important for their credit references, their credit reports, not to be damaged simply because COVID has meant that they have temporary illiquidity. And also in a number of countries, and Australia is one of them, Germany is another major one, and Britain is the third. There are strict requirements about making a filing if the company becomes insolvent. And if those requirements were to be enforced, again, there would have been a race to the courthouse and the courts would have been overwhelmed. So those requirements were suspended. Directors were protected from not filing in accordance with the pre-existing law. And the final point I'd make is that deadlines in various laws, for example, for filing a reorganisation plan within so many days of a filing, were to be extended. Next page, please. So how did Australia deal with this first phase of the period? And without going into too much detail, because I would be repeating what previous speakers have said, because there has been a fairly common reaction across the globe. Our period, in order to be able to automatically wind up a company, is normally 21 days if they don't pay a debt that's clearly owed. That 21-day period was extended to the end of September. So at the time, it was a good 6, 7, 8 months extension. The government has lent very heavily on our major trading banks, has provided them with cheap finance and other concessions, but in return has asked for the banks not to enforce, at least during this emergency period. And landlords were addressed by a voluntary code of practice to prevent evictions. Next slide, please. Directors were protected from not filing insolvency processes just because their company became insolvent, which they would normally be required to do and face substantial civil penalties if they don't. And the government injected a lot of liquidity into the banking system at no cost to the banks, and gave the banks serious encouragement to use that liquidity to support businesses. So that's the first phase, and most countries are still in that phase or are moving into the second phase. So if we can go to the next slide, I'll move to the second phase. The slide after that. Okay, this is the transition. This is the transition from the emergency to the solution. And the main part of this transition that most countries are in at the moment is a process of evaluation. Will their system be able to cope when the emergency measures are turned off? Will their institutions be able to cope when the emergency measures come to an end? Will their laws be able to appropriately deal with the debt overhang? Because if it doesn't, their societies will suffer. To borrow a medical term, the IMF talks about this as flattening the curve of insolvency filings so that the court system and other institutions can cope with it and business can cope with it in a more ordered manner. Next slide, please. And there are several critical elements to this planning and to this evaluation. And the first, which is critically important to the end result and to the solutions that all countries are now, through amendments to their legislation, implementing or will in the months ahead implement. The first one is the triage process. And that is to work out whether companies that are distressed can be saved or not. If they can't be saved, then it's in their best interests, it's in the best interests of their stakeholders, it's in the best interests of of society generally, that they be swiftly and efficiently placed into liquidation so that capital can be recycled into the economy. But if they can be saved, it is important that structures are put in place to maximise the prospect that that will in fact be what happens. And this triage process may need to be undertaken on a sector-wide basis. There are some sectors that perform essential functions. Airports. If an airport is so financially distressed that it needs to go into insolvency and it can't get sufficient finance to continue to operate, well, that's not going to be much good if that's Jakarta Airport, Sydney Airport, Schiphol, Singapore. So part of the triage process is to identify essential industries that the government will need to support. And finally, they need to plan for effective debt restructuring processes. MSMEs have been brought up before, and they're so critically important. SMEs are generally fairly simple businesses. So there's no reason why we can't have standardized restructuring solutions that can be quickly, inexpensively and simply implemented for them. But planning needs to be undertaken to be in a position to hit the ground running on that when the moratoria all come off. There needs to be the availability of post-appointment finance. Andrew expressed the importance of that, and it truly is important, because banks won't necessarily provide it. And we need efficient liquidation processes. As I said before, if a company cannot be saved, it is in their best interests, their creditors' best interests, and society's best interests that they are efficiently, effectively, quickly liquidated. The final 2 points in this transition phase are, firstly, is there going to be a need for a government agency to be established to be a route for capital to be injected back into the economy? In other words, if it is left to private enterprise to provide capital to what will be a lot of capital depleted companies, will that be effective? Now, the answer to that question will be different in different countries. And if in a particular country there won't be sufficient private capital available, then there is considerable merit in the government setting up agencies to inject that capital, either through guarantees or through loans or through equity, into businesses that they assess will be able to be saved with the benefit of that additional capital. And finally, in this interim transition phase, governments need to decide whether the court system will be sufficient to deal with the challenges that lie ahead. And if the answer to that is no, now is the time to strengthen the court systems. Next slide, please. So where does that leave Australia? That's a very good question. Our government is still in the evaluation stage and they have not yet released their plan for phase 3. There have been some rumours that it will involve some insolvency law reform, maybe even some debtor in possession processes, possibly post-appointment financing, ranking pari passu or ahead of secured debt, and maybe some hybrid moratoria along the lines of what's recently been introduced in the UK. But they are rumours at the moment, and so I can say no more about that. I will say in a moment the existing system that is in Australia, but I don't want to spend too long on that because it may be outdated by the end of this month. So that brings us to phase 3. The IMF, in their work, has identified what is required here to be, I guess, the final element of a country's response to the bankruptcy aspects of this pandemic, and that is fighting debt overhang. The financial distress must be addressed. It can't be left to linger. We can't have zombie companies running about everywhere, and there needs to be a plan for how that is to be addressed. Because these temporary measures, the first phase, they will lapse, they will come to an end, as well as macroeconomic tools like income support that many countries have introduced. That will come to an end, and there needs to be a solution. The first part of that solution is that there must be a robust debt enforcement system. The rule of law must prevail. Moral hazard must be avoided. Unless a company has recourse to insolvency processes, it must pay its debts. But for those companies that can't pay their debts, and for those individuals that can't pay their debts, there needs to be a robust insolvency law, and it needs to address 2 aspects. It needs to provide effective rehabilitation for companies and businesses that are assessed as viable, As I said before, there must be a swift liquidation of unviable enterprises. Part of the focus here has to be on out-of-court debt restructuring, on private agreement between the debtor and their creditors. This is a very effective mechanism. It is a cheaper mechanism. It is quicker, and it eliminates the uncertainty of how a court may address a dispute between debtors and creditors. So steps have to be taken to encourage private agreement. One step here that is quite important in my view is a greater use of mediation, particularly in dealing with the MSME market. We need to introduce more what the IMF calls hybrid processes. It's along the lines that Andrew has explained that Singapore has recently introduced. There needs to be more short-term moratoria, giving a company breathing space to address its issues, and pre-packs need to be encouraged. The institutional framework and the capacity of the courts, it needs to be ready to hit the ground running when all the temporary measures are brought to a close. Now is the time to make sure that that will occur. The IMF finally says that it's time to use more modern technology. So where does Australia stand in all this? Well, we still have our largely unamended insolvency laws that have pretty much been in place since the early 1990s. Like Singapore, like the UK, like many other countries, we have what's called the scheme of arrangement, but we have a more ancient form of it. We haven't undertaken yet the reforms that Singapore and the UK more recently have undertaken, and hopefully that is part of the package of reforms that will shortly be announced. We have a voluntary administration process. It's probably quite similar in many respects to the Indonesian process that was described earlier. There are a couple of, the PKPU process, there are a couple of differences. There is no court involvement in our administration process unless someone wishes to object. So there is recourse to the courts, but no necessary involvement. The system, in my view, doesn't work particularly well. The average return is 5 cents in the dollar. I don't think a return of 5 cents in the dollar is something that one can recommend. I won't say anything more about this because I'll just go to my final slide and finish my presentation. That's the key takeaways from what I've just spent the last 20 minutes explaining. The first is that phase 1 is important, and all countries seem to have that in place to varying degrees at the moment. But phase 2 and 3 are even more important. Now is the time to get your insolvency law in good order. Now is the time to ensure that there are MSME specific provisions that will ensure a quick, simple, efficient, and most importantly of all, inexpensive process for ensuring corporate recovery of MSMEs. There needs to be a robust corporate rescue process. Post-petition finance and role of mediation are both important. You need to ensure that your court system will be able to handle the insolvencies that lie ahead. There needs to be a triage process to distinguish between companies that can be saved from those that cannot. And finally, and also quite importantly, there is a need for consideration for whether a government funding agency will be required in order to ensure that there is appropriate access to capital in the market for distressed enterprises. So with that last comment, I will finish there.
Thank you very much, John, for the very insightful presentation. So basically, and also for sharing with us the 3 phases that was initiated by IMF in facing this very situation. Like, you know, first initiative is like first phase is on the emergency response and then transition and then debt overhang. So it seems like it's up to still far away from things getting better. If you look at that, we are going to get into the third phase, which is debt overhang later on. And also, it is interesting to note on your on your closing remarks that now it's time to look back the insolvency laws to see whether it's efficient and then robust, or it's effective to settle all of these debt-related issues. Now, going to our last session, where we are now already 11 minutes behind the schedule, but we haven't got into the Q&A. So I think we cannot discuss all of the questions. And what if, like, ask you guys to what, like, we have like 10 minutes more to just give a response to some of the questions being asked by the participants. Will it be fine with you? 10 or 15 minutes? Because we are already behind the schedule. I think it is yes. So there are 5 questions asked by the participants. One is from Wina Ratnawati, 2 questions, and then Richie Maurin, and then from Malumas KPKNL Bandung, 2 questions from Mariska Anita. Let me check. Addressed to Andrew, question from Ibu Wina. What is the insight measurement to allow some company to die while some company to live or to continue their sustainable life? I see that in Andrew's presentation as well as in John, a bit of in John's presentation. So this addressed to Andrew. If you may add something, then this will be fine. That question number 1. And I think our question go to Andrew. One more, may I get the presentation material from the speakers? That's a question raised by Polemas KPKNL Bandung. If there's objection on the sharing the presentation, will be really appreciated. But this is a question from one of the participants. Let me on the, wait a sec. Well, a question addressed to Dr Ricardo from Richie Maurin. 2 questions. Why there are so many receivers or administrators in a case of suspension of payment obligation PKPU or bankruptcy recently? Berarti 3 up to 5 in one case. Question number 2. For a joint operation agreement for building development, do you have any advice for the possibility of CO parties to file PKPU or bankruptcy petition? How do they simply prove any of the signing debt or obligation in the commercial court? I think question number 2 is pretty much on advising some real issues. So it's up to you to answer the question. I think we only have this are the questions to be discussed later on because we have not much time to spend. I think first time to Andrew to respond and then followed by Jen if you have any answer, then followed by Dr Ricardo. Time is yours.
Okay. Yeah, so let me just quickly answer the questions. First question is, what are some of the insights to decide whether to allow a company to continue or to die?
Yeah.
You ask a lawyer a question, they give you the lawyer's answer. The lawyer's answer is it depends on the circumstances. But it's correct because our laws have, I'll tell you how the courts have viewed it. The courts have asked itself at different stages, because if it's early on, you just start, if you act in good faith, there could be some prospects, we allow it. As you progress through the time, because you want a longer moratorium, the courts have demanded more. So the first big point is really when you ask this question, at what stage have you enjoyed moratorium? How much opportunity? The later and the deeper you go, the courts are going to be stricter. Number 2, you need to answer this question, what is the cost? Is this cost temporary or is it something which is long-term? Because things which are hopeless and long-term, let's not waste time. But it is some prospect. So the next question is, and that's not just a question of law, that's a question of what is it on the ground? 3, is there fraud? Fraud is a very important consideration. If it's fraud, maybe there's still some value which can be salvaged, but fraud, I think, is a different category. And if the fraudsters are there and business, the company doesn't have real business, I think it's not going to work. Now, I'm very alive to that. There are many more questions, so I'm just going to give just 3 points very quickly. The other point about, which comes from polemics, is the question of itikat baik, the question of good faith. For some, I think in the Netherlands, they've moved it more to reasonableness. So the position is this, because what is itikat baik? Itikat baik, people say sometimes is because it's all good faith. Itikat baik, I agree to lend to you so that I can actually enforce. But there's also another side of good faith in the other side. But this is not my fault. This is COVID. Whatever the point which I was making is this: you cannot just leave it to the good faith of the parties or the ability to negotiate. This is a time, masa ini, this is a time where it is necessary for the laws to intervene with contractual rights, with safeguards. I've talked about some of these kind of safeguards. So to answer your question is, there's always two sides of itikat baik. Of course, some people are extreme, but this is a time where the law must try to shape and intervene with some safeguards. And two aspects of that. Number one, of course, you need to go to, if you need to go to court, you need to go through the assessors under the COVID Act. Or the other point is this: because the law is already there, it encourages the parties to negotiate. Don't negotiate, I'm going to do the remedy. That is now the law helping the negotiations. Those are my 2 quick points.
Can I just quickly add to that?
Right.
I mean, I think part of the answer is it depends on the quality of the business operation. There have been a lot of businesses that were very well run, very profitable, good, robust business plan, but COVID has just destroyed them temporarily. You know, obviously, while there's a lockdown that has occurred in many countries, businesses can't trade. That has caused insolvency for so many really good businesses. But the point is that once that finishes and all the shops open, business resumes, if that business has every prospect of being able to recover on a profitable basis, then that is the type of company that needs to be supported by an effective debt restructuring system so that it can be helped back on its feet.
Okay, thank you, John. Now, Bang Ricardo, you're next.
Yeah, thank you. Thank you for the question, Maureen. If we see from the bankruptcy law, it is not clearly stated how many receivers and or how many administrators that would be that should be appointed in handling the suspension of payment or bankruptcy. In handling the bankruptcy, but in practice, when we see, I think it depends on the complexity of the case or the complexity of the bankruptcy estates, and as well as the numbers of the amount of debts, and also the numbers of creditors. But the point is, even though the numbers of receivers or administrators are appointed, I think in 3%, for example, but their fee is counted as one. So, for example, if the receiver will get like 10,000, one receiver can, I mean, their fee is, for example, 1,000. If there are 3, it's not, it does not, I mean, triple to be 30,000. No, but it's 10,000 divided into 3%. So doesn't matter if the number of the receiver or the administrators more than one. But in practice, that could be more effective to for them to handle the bankruptcy or suspension of payment process in a better way. Since sometimes not only because the complexity of the cases, but also the location of the assets everywhere. So that's the answer for the question number one. The question number two, joint operation. I mean, according to Indonesian law, joint operation is not classified as a legal entity, but that's a partnership. So if the joint operation, I mean, say that A and B GO, for example, so the party are counted into two. You cannot say that joint operation as a party as the petitioner, but must be say A, petitioner one, and B petitioner two, that is joined in joint operation as a petitioner. So this is joint operation is not a legal entity that can present as a party to petition for bankruptcy. There are two parties, then they must be mentioned as a parties and said that they are joined in a joint operation agreement. That's first. The second is how to assure that the claim has been due and payable. Yeah, of course you must look at the contract. Yeah, usually the joint operation contract relates to the construction. Yeah, so you must check that and then see to the event of defaults, and also sometimes see to the to a claim that has been sent, and also the response of the debtor that whether they have acknowledged the debt, and also they acknowledge that their inability to pay. We are a bit different with Singapore and Australia. If Singapore and Australia, they try to divine what they call as a due and payable in simple way by saying, for example, there must be at least the demand letter, yeah, to be sent, like a statutory demand to be sent to the debtor, and the statutory demand must clearly state that what action they will take if they fail to pay the due and payable debt. But the point is, if the debtor does not prove that to the court that the demand letter within the 21 days, yeah, then the petitioner for bankruptcy will be accepted by the court. But we don't have that in here, because according to Article 1838 of Indonesian Civil Code, if it depends, we see that to the contract. But if there is no clear event of default in the contract, but we can establish the event of default by sending a demand letter to the client, but there is no specific days to be needed. Yeah, as far as we can send them and then they don't give a response, then we can put that as evidence to the court that the claim or the claim that we put as a base of petition for bankruptcy has been due and payable. That's for the question number one, and for question number two, that's from. I
think it's all answered, Bang.
Sorry.
Two questions already answered. Yeah.
I think I still have one other question from Mariska Anita. Is it?
Yeah, but the time is not much. But
oh yeah, okay, please. Yeah,
that's fine for you.
Okay.
If maybe we can give a short answer, that will be fine.
No problem. Oh yeah, yeah. This is yes. I think this is the question is, can the lessee or can the lessor terminate the leasing the lease contract because the lessee cannot pay the monthly, yeah, for the reason of this pandemic. I think the situation, this pandemic is not like our economic crisis in 1998 or our global economic crisis 2008. This is very specific, and every country has acknowledged that this is global pandemic, and this somehow come to the position of this could be classified as an external, reason for the business player not to be able to pay their obligation. So for this, the government, as we presented in my presentation, has also helped the business player by issuing, for example, regulation, POJK regulation, to leave the small and medium and small or business to be relaxed or to be restructured. But again, to this question is. Even though the situation is very hard, but it does not. I mean, the law does not simply say that the people or the debtor cannot pay their obligation can be released from their obligation to pay just because of the pandemic. This pandemic, it must be a proof that the non-able to pay closely related or closely relates to the pandemic. So if the pandemic caused the inability to pay, then there would be a reason for the debtor to go away or to prevent not to be brought to the bankruptcy process. But this must be approved, yeah, by the evidence. So this question say that there is no force majeure like clause in the agreement. According to Indonesian law, force majeure is not something that is is borne by the contract only. This is borne by the law, because under Article 1254 of Indonesian Civil Code, we have the law says that then when the debtor cannot fulfill their obligation because of the external factor out of their capability, then they cannot be put responsible for that, then they would be waived from their obligation to pay. That's under the law of Indonesian 1254. So even though there is no force majeure clause in the contract, then force majeure will apply as far as the force majeure itself can be approved happen. That's the response. Thank you.
Okay, thank you. So I mean, it's very, very rare situation, a very rare moment. I think there's one question that was addressed to all speakers except to Dr Ricardo. Sorry, I think hopefully that all speakers can answer this. From your PR, it's
I think
it's about in your opinion, what is the best formulation to regulate cadence of remuneration or fee for receivers and administrators using what basis? That's from Department of Law and Human Rights, from the Minister of Law that will deliver presentation earlier today. So if you may answer, that will be great. Andrew, Robert, as well as John. That's going to be the last question to answer.
Okay, so very quickly, the Singapore system, where you talk about insolvency practitioners, we have devised a method whereby you would, if you can reach agreement with the creditor committees and what have you, that's approved. So we have it 3 stages. Number 1, you try to agree with the creditor committee. If not the creditor committee, the general body of creditors, if not with the court. If you go to court, there's a process of transparency. We have a schedule in terms of what information needs to provide. But very often, these things are negotiated, we agree. A small number of them get, only very few of them actually go to court, because it's a 3-stage process. Committee of inspection, general body of creditors, court, then you have schedules. The other thing is this, as part and parcel of our practice is this, because very often 1 year, 2 years down the road, you say this is so much of a cost. For some of the restructurings, we have a practice of a cost schedule, your cost estimates ahead. So that actually is helpful in terms of maintaining, not at the end, an indication at the beginning, the processes of control with sufficient information depending on the level. That's my big answer.
All right, John, you have an answer to the question?
Yeah, look, our system is, I guess, similar to Singapore's system. There are some differences. I mean, the first port of call are creditors, and if they can be persuaded that the remuneration is fair, then it is paid. If they can't, the administrator or receiver can approach the court and try and persuade the court that the remuneration is fair. Most of the remuneration in Australia is calculated on a time cost basis, but occasionally that gets quite criticised by our courts, where the amount claimed, even though validly calculated on a time cost basis, is not proportionate to the sum involved in the estate. I mean, if there's only $100,000 worth of assets and the remuneration is $95,000, you know, you think, well, what was the point? My final comment is it's a vexed issue. I don't think there's any right or wrong answers. I think there are, there are some answers that are better than others.
Great. Robert, do you have any response to the question? In your jurisdiction, how is it decided?
Yeah, I think I would like to make a few remarks. First of all, in our system, the remuneration of the trustee is determined by the court. And if there are insufficient funds in the estate, the trustee will not be fully paid. But there are a few short remarks I would like to make about continuation. First of all, in general, if the business is viable, it's possible to continue it either with the same debtor or in a new company. But there is another problem here, and that is that in insolvency proceedings, we focus on one debtor. The whole system is built around its reorganization or liquidation. But the present situation we have with COVID-19 is that these insolvencies affect the whole economic fabric. Because if debtors go down, often their suppliers or other contractual parties get into big problems as well. And therefore, it's necessary to approach this not only from the angle of the individual insolvency proceedings, but more look at it at our society as a whole. That's one of the reasons why governments devise support programs. But I think it's very important to keep in mind that we should not look only at the individual debtor, but look at its surroundings and what's going to happen. Thank you.
Okay, thank you very much, Robert. Sure, please.
No, just a point is, I mentioned earlier, akan datang. We're going to have a process of simplified procedures. The insolvency practitioner, meaning the accountant, is going to charge a very low fees. The lawyers are going to do pro bono for the SMEs. I do my COVID determinations, $100 per determination, Singapore dollars. Okay, a full determination, at least a summary determination. This is what we are doing now. The insolvency practitioners in Singapore are coming out to lower costs for the SMEs for certain kinds of claims, because we need to do our part at this point of time.
Pro bono service as a trustee and administrator as well?
Okay, the government doesn't give us too much. It will be a balance, but all of us are required to do a bit. Our contribution to these difficult times.
All right, that's gonna be interesting. Yeah, I think we are now happy to the end of the session, and thank you very much for the time, for the sharing of the knowledge and experience and framework. And again, thank you very much to Dr Ricardo for your very fruitful presentation, and then to Robert, as well as to Andrew and John. And hopefully, I believe that all of what you have shared with us were very helpful and very insightful, and will be, as mentioned by a minute earlier by the minister, that the government needs support from us in terms of providing some input suggestions in terms of preparing regulations suitable for the situation. And thank you again, thank you very much. And we look forward to seeing you again in the next opportunities. Thank you. Now, I give back the time to Fiona to continue with the session. Thank you.
Thank you, Andre. Thank you, John.
Thank you very much.
Thank you, Robert. Thank you very much. Thank you.
Thank you, everyone, for taking the time to join here. It has been my pleasure to host this event, and I wish you all a pleasant day and have a great weekend. Stay healthy, good weekend and take care. Bye-bye.
Thank you.
Thank you. Thank you. Thank you.